We are on People versus Mr. Zachary Berge, file number 25-3651F8. Appearances, please.
David Denham on behalf of the people. Robert Champion appearing on behalf of Zachary Berge, who is appearing by Zoom from his treatment facility.
All right, thank you. Mr. Berge, are you able to see and hear us?
Yes.
Thank you. We are here today for the entrance of a plea pursuant to a pretrial agreement. Mr. Denham, what is that plea?
Thank you, Your Honor. The plea offer is that if the defendant pleads no contest to an added count 3 of attempted felonious assault, then the remaining counts as well as the enhancement would be dismissed. I would note that as part of this plea offer, restitution would be reserved for all counts, if any. This is primarily designed to allow for restitution as to the door frame and the siding that apparently was damaged.
All right, so count pleading no contest to added count for the attempted felonious assault, which would make it a 2-year. And then the court would dismiss counts 1 and 2.
Correct.
Yes, Your Honor.
Yep, and then there would be a reservation of restitution. All right, thank you. And the reason for the no contest plea is, Mr. Champion?
Your Honor, at the time of the incident, my client was extremely intoxicated. His blood alcohol content by PBT was 0.181.
Mr. Berge, is that how you wish to resolve today's case, sir?
Yes. Yes, Your Honor.
All right, please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes.
You may lower your hand. Mr. Berge, back when this incident originally took place, which was November 15th of 2025, were you on probation, parole, or bond?
I was on bond, yes.
Was he on bond?
He was, Your Honor, for operating while intoxicated
As a misdemeanor then?
as a misdemeanor. Correct.
If it were a felony, there could be what's called consecutive sentencing, but because it wasn't a felony, I don't need to discuss it any further.
So the court's aware he's already led to that and has been sentenced.
All right, good, thank you. All right, Mr. Berge, you are currently charged on a felony information with 2 counts. Count 1 is assault with a dangerous weapon, also known as felonious assault. That is a felony punishable by up to 4 years and or up to $2,000. I'm told that you're going to plead no contest to an added count 3, that is an attempt of that charge. That would again be an attempt of assault with a dangerous weapon or attempted felonious assault. Now, to understand the maximum punishments for attempts, it's a little bit more confusing than exactly how I said it a moment ago. In effect, it cuts the maximum punishments down in half. However, because it's a felony less than 5 years, it's actually, I could still sentence you up to 5 years, but I would still be limited to, I remember right, let me get it right. I don't know why I don't have it memorized, but I don't. It ends up being that the maximum can't be any more than half. So it's worded differently, it's confusing, but basically the maximum punishment would be up to 2 years. Do you understand?
Understand.
All right, thank you. Also, there's a charge count 2, malicious destruction of property in an amount less than $200 as a second or subsequent offender. That is a misdemeanor. Why does it say second? Actually, because there isn't, well, because you had it would have been a prior. That makes it a misdemeanor punishable by up to 1 year and or up to $2,000 or up to 3 times the amount of the property destroyed. However, count 2 will be dismissed. Do you understand?
Understand.
Okay, now by entering a plea of no contest, it has the same impact as a guilty plea. The difference is instead of requiring you to recite a factual basis, I'm going to be given an exhibit, most likely a police report, And I'm going to use that to determine your guilt. I can only take a no contest plea when there are certain conditions or qualifications. One of them is significant intoxication where the person would not recall or does not recall what happened. It also could be for potential civil liability, which means you could be sued for any injuries that were sustained. Do you understand?
Yes.
All right. Now, what's really important to understand also is that when I take a look at this exhibit, which I already have here with me, you can't come back and say, well, that line there isn't true and that paragraph over there isn't true. You understand that?
Yeah.
Because when you plead no contest, this exhibit is used and entered into evidence and is not challenged. Hence the phrase no contest. Plus, it would make no logical sense for a defendant to come in later on and say, well, that paragraph's not true, when I'm taking the plea based upon the concept that they can't remember it. Does that make sense?
Yeah.
All right, good enough. Now, if you enter a no contest plea and I accept that plea, you'll be waiving certain rights. That includes the right to be tried by a jury, the right to be tried without a jury, if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify at a trial if you were to choose to testify. Mr. Berkey, do you understand those rights?
Yes. Yes, Your Honor.
And even more importantly, do you understand that by pleading guilty, if you plead no contest and I accept that plea, you will be forever waiving those rights as they apply in this particular case. Do you understand?
Yes.
Thank you. Additionally, any appeal as to the conviction and sentence pursuant to the pretrial agreement will be by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would only otherwise be appealable if you were convicted at a trial. You also will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record, or the plea was not of your own free choice. Have there been any other promises, threats, or inducements to get you to plead no contest today that we have not yet discussed?
Yeah.
Now, hold on. I think you're in a rhythm of saying, yeah. Let me go back. Other than the terms of the agreement, which I've already gone over, have there been any other promises, threats, duress, coercions, enticements to get you to plead guilty that you haven't told me?
Say that again. I'm sorry. The last part. The phone is just it keeps going off.
Okay. It does. I don't mind. I think I have a lovely voice. Other than the terms of the agreement, which was you plead guilty to the attempted charge and the other charges be dismissed, were there any other promises, threats, the word coercion, duress to get you to plead guilty that I haven't heard about yet?
No.
Oh, good. Thank you. Now,
Sorry about
Mr.
that.
Harris, that's okay. I don't mind. Mr. Champion has probably talked to you about potential sentencing and the sentencing guidelines. He's probably tried to give you an idea as to what he thinks they might do to help you or sentence you and so forth. The question is, has he or anyone promised you exactly what would happen in this case of the sentence?
No.
Thank you. I also highlight for people that sentencing guidelines are not mandatory. Do you still wish to enter the plea of no contest?
Yes. Yes, Your Honor.
As to the added count 3, attempted felonious assault, how do you plead?
No contest.
Thank you. All right, before accepting that plea, I have been provided here an exhibit. That exhibit is a Missaukee County Sheriff Incident Report number 25-2470-157. It consists of 11 pages. Mr. Denhouten, are you asking the court to accept that for the taking of the no contest plea?
Respectfully, the people are, Your Honor.
And do you believe that the interests of justice do not require the resuscitation of a fact based upon the intoxication and potential civil liability?
Yes, Your Honor.
Mr. Champion, do you agree with both?
I do, Your Honor. Thank you.
People's Exhibit number 1 is hereby admitted into evidence. The court also finds that the interests of justice do not require a factual basis to be provided by the defendant, and therefore a no contest plea is appropriate. I'll note that this exhibit, which is now admitted again, contains a date that's consistent with the felony information as well as the jurisdictional locations here within Missaukee County. The court further recognizes that the witness alleged in added count 3 is the witness described here inside the report. And the court beginning specifically on page 2, carrying into page 3, there's a description of the events that form the basis. Mr. Denon, you believe this exhibit provides a factual basis to support the plea?
I do indeed, Your Honor.
And are you aware of any other promises, threats, inducements?
No, Your Honor.
And do you believe that the court's compliance with Court Rule 6.302?
Yes, Your Honor.
Mr. Champion, do you agree with all?
I do, Your Honor.
The court agrees and finds the defendant they has made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the testimony in the exhibit admitted by the defense is here satisfies the elements for the offense. So then it's found guilty of added count 3. Counts 1 to 2 will be dismissed at the time of sentencing. Mr. Berge will be back here for sentencing in about 4 weeks. Between now and then, you will have contact with an agent from the Michigan Department of Corrections. That is also known as a probation or parole office. They're going to give you a packet that you're going to complete and then turn it in. They will then schedule an interview with you. You have the right to have your attorney present during that interview. And once this report is prepared, Mr. Champion will meet with you and go over the contents. Each side has the right to request corrections, make objections to the contents and the scoring and so forth. This report will include a description of the offense, description of the pretrial agreement, any statements, information you make or provide, as well as information about prior criminal history, if you have any, performances on bond, performance on probation. It will also include a scoring of the Michigan sentencing guidelines, which sets the minimum end for a sentence. That, however, is not mandatory. Do you understand?
Yes, Your Honor.
Anything further, Mr. Denon?
No, Your Honor.
Mr. Champion?
One thing, Your Honor, though it's not part of the plea agreement, at the time of sentencing, I will ask the court to consider treatment under Home and Youthful Training Act.
All right, thank you very much. We'll deal with that when we get to it. Bond hereby continues as previously last set by this court. We are adjourned. Who's exhibiting?
That's my.